helping you have great relationships with people on your support team, structuring their incentives in those relationships so that they want to make the business overall better. And it's not just all one-sided or selfish either for them or for the business, but like aligning their incentives with the incentives of the business. That's going to cut down so much stress and make your business better and easier to operate, but also help you build a really great corporate culture.
Welcome to the Draw Your Dice podcast, the show that calls on the champions and new contenders of the tabletop RPG arena. My name is Jeremy Gage, and I am learning about tabletop game design and publishing. If you are a budding game designer or a veteran looking for fresh musings, stay tuned as we learn about the inspirations, processes, and philosophies of professionals in the industry. Hello, everyone. Welcome to the Draw Your Dice podcast. My name is Jeremy Gage, as you heard in the intro, but it's not about me today. It's about my very special guest. This is going to be a unique, sort of business-centric episode for all you game designers out there. Today's guest is the founder of the Executive LP and creator of Profit from Legal, a program specifically designed to help small to medium businesses use legal support to improve profitability. They are also a preventative lawyer who serves small businesses and startups. They are the author of the How to Structure Your Business for Success and will be publishing a book called Profit from Legal. And finally, they host the same by the name podcast, Profit for Legal. With that, I would like to introduce to you Noel Bagwell.
Thanks for having me on. I appreciate it.
Hi, Noel. It's a pleasure to have you here. For those, me and Noel connected on this site called Audrey.com. It's basically like a collaboration podcasters resource situation that I'm still.
It's Audrey.io.
Yeah,
actually, remember?
Audrey.io.
Yeah, if you go to Audrey.com, you'll end up in a different place. But Audrey.io is great. It's a great platform, isn't it, for collaboration? If you're a podcaster, I'm a podcaster, you're a podcaster. And as long as you have a podcast on Apple Podcasts, you can connect through Audrey.
But, for the people who may not be aware, in addition to whatever I said in my intro, why don't you give a brief introduction of how you present yourself to the world for people who may not be aware of who you are?
Yeah, so I'm an entrepreneur first. Also happen to be a lawyer. Went to college and got a degree in philosophy back in the day. Went to seminary for a year, did not stick, left without completing my master's of divinity, worked in luxury property management a couple of years, and then went to law school. And when I was there, my mentor really opened my eyes to the world of economics. I got top marks in the economic analysis of law class, took all the business law classes I could take, and really wanted to position myself to be in-house counsel at a big company. I wanted to be the general counsel for a company. But when I got out, the legal market in terms of jobs and that sort of thing was still reeling from the 2008 financial crisis. I mean, it had been a few years, but things had not really recovered. And even though I was offered a job with a lawyer that I had clerked with in law school, he made me a very interesting offer that put me where I am today. He said, you can either take a job as an associate in my firm, or I can rent you this office space in my building, and you can just hang out your shingle, be your own boss. And, of course, with my entrepreneurial streak, I was like, oh, okay, well, let's do that. So I did. I hung out my shingle, and I was super miserable. Like a lot of people who start a business, I knew what I did, but I didn't know the business of what I did. There's working in your business and then there's working on your business. I knew how to work in my business. I knew how to be a lawyer. I didn't know how to do law office practice and management really well. So, getting new clients, like building sales funnels. I mean, it's a business, right? Your law firm is a business, and you have to build a business. You have to do marketing. You have to do sales. You have to do accounting. You have to do human resources. There are like all these aspects of running a business, no matter what your business is, whether it's creative or it's legal, or it's providing any kind of goods or services. You have to know how to run the business. And that was not something that I was really well prepared for in law school. So when I got into practice, I had to figure it out for myself. and I wasn't very happy. But I did have some clients who were coming through my office that had the same problem that I started to notice. And I think the first reason to start a business is because you notice a problem in the world that you can solve and that you can charge other people to solve. And the problem that I noticed was that small business owners had preventable legal problems, but they were not hiring a lawyer in advance. They were not getting any kind of preventive legal service. And I would ask them, why didn't you hire a lawyer in the first place? Why are you now paying thousands of dollars in litigation expenses for this lawsuit when you could have paid a couple $100s to have a contract, and avoid all of this nonsense? And they were like, well, lawyers are expensive and they charge hundreds of dollars an hour. And really, it's more expensive to wait until you have the problem than it is to prevent it in the first place. But it was difficult for them to quantify from where they were in the process. And so what I decided to do was reinvent the business model for a law firm from the ground up and really start asking the question, if I were an entrepreneur or a small business owner, what would I want my relationship with my lawyer to look like? And so we oriented that around a subscription-based legal service, and predictable billing was the real first answer that we had. If businesses could budget for this, if they weren't paying by the hour for the lawyer, if you're paying by the hour, you can't budget for the lawyer because you don't know how many hours they're going to spend. You're agreeing to a rate, not a price. But we thought, okay, if we can just make this something that they can budget for, then they can have the lawyer in advance, and then it's just our job to communicate, okay, this service really is worth what we're charging for it. Here's have a good conversation about the value proposition. So the first half of my law firm's existence, that's really, or more than half really, up until about last year, that was really what we focused on, was outside general counsel services, which is just ongoing legal support for your business on a subscription basis. And charging a value-based fee and not charging by the hour for those services. And then recently, like last year, we started developing profit from legal. Because honestly, if I'm really honest, while the outside general counsel subscription-based services did what they were designed to do, it didn't generate as much interest in the service as I thought that it should. And I started asking why that was. Why aren't we getting the kind of response that we ought to be getting? And the answer was two things. Number one, I wasn't really like advertising and marketing except by creating content, word of mouth and stuff like that. So I wasn't going like broad spectrum. I had very little brand awareness, and still to a degree do. But more than that, we weren't having conversations about return on investment. Like if you spend X dollars on legal services, you're going to get Y return on that investment. How do you get lawyers to demonstrate that they can pay for themselves, essentially, and then some? And I could point to success stories that I'd had with my clients, like had a client who paid a little less than $17,000 for a year of legal services. And in a single weekend, I saved him over $50,000. So like the value proposition was strong. I had a different client that had a mergers and acquisitions project, and he paid under $40,000 for that M&A project. We saved over $1.5 million. The value proposition is enormous. Like hiring the lawyer in the first place in a preventive, proactive way is a really beneficial thing to do. But communicating that to people in a way that gives them enough confidence to hire you is actually a really difficult thing. So that's the journey that I've been on in a nutshell.
Wow. Yeah. I mean, for me, I know very very little about legal matters and legal tools as well. It always comes to be a headache for like taxes and things like that for me, and I know this isn't sort of a finance directed episode, but my point is that what it sounds like to me, and from what I've done in some cases of my own personal research, both for you and in this sort of arena, is that I love that you approached the concept of defeating. I watch a YouTube channel called The Future with Chris Do. Great channel for anyone who wants to get some insights on how they approach graphic design and logo design in a business sense, but also approach business matters for creatives in different fields. But Chris often harps about the value proposition process of pricing. What is a logo worth to this mom and pop shop in the middle of Kentucky versus what is this logo job worth to Apple or Nike, right? And those prices are going to be different because of both A, the amount of reach that particular brand has, and B, what is it they can afford? Because, Chris always says, I'll do it for a sandwich for the mom and pop shop. I don't care. Like, I have 10 years of logo experience, and it's going to take me 15 minutes to figure out something really nice for them, and it's only going to touch their storefront. Whereas for Nike, I'm going to charge $2.6 million because that's what it's worth to them. It's going on clothing, it's going on boxes, it's going on websites, it's going on a ton of brand awareness stuff. And so I really love what that value proposition, why I bring this full circle to us, is that what I love about this is that it creates clarity, and it also creates the ability to negotiate what it's worth for both you as the provider of the service, but also for the person hiring you, right? Because you talk about how, someone spent $17,000 and saved themselves $40,000, right? Depending on the size of your business, for me, like, I don't have a lot of money to spend, but I would love legal advice. Is it that I'm only trying to solve like a intellectual property problem for over the course of the year for all of my content, right? Then maybe, I'm making up numbers. I don't know what the exact value would be. For me, it's worth $5,000 a year, right? To solve maybe $10,000 worth of promise. I know that seems maybe small for you, but I'm just throwing out, what I like about it is that it says, okay, you're saying that this is worth $5,000. Is that worth $5,000 to me? Is this something that we can continue to go on, or is this something we negotiate like halfway through the year, right? I haven't really touched base with you for any legal services or something. Can we restructure the contract or something? Whereas hourly.
And so we do a lot of that thinking for you too. Like as your lawyer, we do a lot of that thinking for you, and we show our work, right? It's like a math problem. You have to show your work. You have to show the client how you got there. So what we do is statistical analysis, and we look at what businesses spend nationwide, like the statistical averages and like what they report on, what they spend on legal services. And there's this ancient quote from an ancient Roman philosopher, and it goes, everything is worth what its purchaser will pay for.
Right.
We know what things are worth because we know what people have been willing to pay for those services. And so we can look at what people have paid, and then we can adjust those like national averages for various markets. Like Dallas is going to be 11% more than the national average. Cool Springs in Nashville is going to be exactly the national average. Nashville downtown is going to be 1.5% higher. Like you can go into pretty much every major market in the United States and see what the adjustment percentages are off the national average. And then you just take the average spending and adjust it accordingly. And so you can kind of know what various services are worth in various markets. And we use all of that in a proprietary value-based billing formula that we developed over the course of about 2 years. And we use that to, so basically what I can do for a small business owner is put in the size of their business into our formula as measured by their revenue. And if they're like a $1.5 million business or an $11 million business, I just put that figure into our algorithm, and it tells us what their annual budget should be for preventive legal services based on legal spend, and we adjust that based on the number of attorneys that we have working for them and the market that they're in. So we can really create a scalable service because, to your point, you're right. A bigger business, those services are worth more. They're going to pay more. It takes more effort, more time, more legal acumen, all of those things that go into what constitutes the legal fee. It takes more to support a big business than it does the mom and pop shop. So the mom and pop shop should spend less, and that's just common sense. And that goes into the scalability of our services. And we have a couple of services for businesses that are under $1 million in revenue that are designed, they're flat fee services, like our Legal Lifeline, for example. Legal Lifeline is $4,800 a year. It's only available to businesses that have less than $1 million in revenue. And it includes unlimited remote legal consultations, unlimited legal research, and some other really key services. So like you can basically have this lifeline to your lawyer, ask any question, get any answer that you need. You don't have to worry about feeling like you're in a cab with the meter running. It's this sort of concierge legal service. and it's really designed for the micro business and for the startup. And that was a solution that we came up with to make sure that, they had incentives to call the lawyer, because a preventive lawyer can only do their job if you as the business owner call them early and often. So if someone signs up on our annual Legal Lifeline plan, we send them an email every week that says, hey, don't forget to check in this week for a 20-minute chat with your lawyer. Just tell us what's going on. Just give us an update. And we use that to forecast their legal risk and give them recommendations about what they should be doing based on the life cycle of their business. Like, what phase are you in? What are your current goals? What are you trying to accomplish? What new assets, intellectual property, whatever it may be, are you developing? And we really try to hit 3 dimensions of every business in terms of, what we're delivering for them. One is creating value, adding value to the business so that your business is valuable. The second one is stress. And then the third one is risk management. On my podcast, on the Profit from Legal podcast, I just recorded an episode with a friend of mine in Trinidad named Kevin Valley. He is a business valuator, certified business valuator. So his whole job is to put, the value stamp on businesses. Your business is worth this, right? And he said the value of a business comes down to 2 things. One is risk, and which can drag down the value of your business. And 2 is growth, which pulls up the value of your business. So anything you can do to lower risk and increase growth is going to dramatically amplify your business. And Kevin says that legal is one of the biggest force multipliers for that.
I agree. Me and my partner are currently in this sense of like trying to get our taxes together, especially after the whole COVID lockdown situation. Lots of people's businesses are changing, and how we approach our own personal finances have really adjusted in the last year. And, it's becoming a really big headache for us to try to do it personally. I'm like, hey, what if we just spent the $300 to just like take this to someone who's going to make sure every nook and cranny is filled out, and that we get as much back, and we're not like kicking ourselves in the ass later for not, accounting for this asset or something to that effect, right? So
it's a good thing to spend your stimulus check on, but especially if you haven't really been able to do it in the past. Getting that stimulus check right now, the Biden bucks or whatever you want to call them, like getting that in your bank account, it's a great opportunity to test out using a lawyer, using an accountant, something that you've always told yourself, I wish I had done this, or I wish I could do this, but I don't really have the money. Well, now you have a little extra money. Try it. See what happens. And I think you'll be pleasantly surprised. I've been having my taxes prepared by somebody else for over a decade. When I was in college and, I was working 3 jobs to put myself through college, and just kind of struggling for a long time, I know what it's like to live paycheck to paycheck. I know, and I did my own taxes and all of that. But I think it was the first year that I ever had someone else do my taxes. They looked back and they found, they had me like review, they had me bring in my prior year's returns for them to review as well. And they found money that when I was in college and I filed my taxes myself, they were like, oh, you didn't claim this. I don't know if it was a credit or a deduction or whatever, but it made a significant difference. Like they said, let's go back and file a revised tax return for that year. And, I think I got some money back from the IRS. I don't remember how much it was, but it was kind of cool. It's like, wow, okay. So using an expert, they really are going to see things that, even though I felt competent to do it myself, and I thought, oh, it's not really that complicated. I'm just a regular W-2 wage earner. It's not like I have a whole bunch of investments and things or whatever. I can do this myself with TurboTax. I remember when I don't know if you remember this, but Tim Geithner, who was like Obama's Treasury Secretary, was called in to testify before Congress about his tax returns and some irregularities. And do you remember this? It happened like, oh, okay. Well, he did. And he blamed the irregularities on TurboTax. I was like, dude, you're the Treasury Secretary. You're in charge of the IRS. Like, that's your whole job. And you're going to look over here and blame TurboTax? Yeah. Okay. Yikes. So maybe have an expert do it. Maybe don't use, I'm not here to knock TurboTax. That's fine. But maybe before you file it, like have a real CPA review your tax returns.
Yeah. I think it's totally worth it because eventually like it pays for itself, like the $300 or whatever you spend on a CPA, they make you a $300 additional dollars you would have never found somewhere, right? Like right there, it's free money, and you did it right. Like you don't have to, think about the IRS potentially breathing down your back 5 years from now,
That's a big thing that could be saving you the cost of an audit, because the IRS sees that return that a CPA has signed off on, and they think, okay, if this was the taxpayer, they have every incentive to lie and to cheat on their taxes. But a CPA, if they lie and cheat on someone's taxes, then the CPA could lose their license and lose their livelihood. So they don't have quite as much of an incentive to lie. And I think that therefore, there's been some studies on this, but if a CPA signs off on your tax return, if they prepare your tax return, you're at the margins less likely to get audited. You still could get audited. There's still a good chance of an audit, but if there's something that flags the IRS's system to trigger an audit, then it could still happen. But at the margins, it's less likely to happen. Using a professional in advance, whether it's a lawyer, an accountant, whoever, right? They are going to be able to create real value for you. It's not just a cost center. And what we're doing with Profit from Legal is really designed in a specific way to show people how to use legal services and to actually accompany them. It's not just like a mastermind class. It's not just, are you familiar with the levels of implementation?
I am not.
Okay, so for gamers, this is a really great concept, right? Because it's a level system. Okay, so you have level 1 is let me show you how to do this. Level 2 is let me do this with you. And level 3 is let me do this for you.
Yeah.
And so this is level 2 implementation. Profit from Legal is we are accompanying you. We are hand in glove with you, developing systems and processes, intellectual property assets, programs, and job responsibilities and roles and workflows with our clients. We're developing all these things with our clients so that they are equipped to use legal services in order to be more profitable. And most small business owners, just like me, when I opened my law firm, I knew legal, but I didn't know the business of law very well. Most people that open a business, it's like, well, I'm a creative. I know how to do graphic design, or I'm a creative. I know how to do web design, or I do copywriting, or I do voiceover acting, or whatever it is that you do. I know how to do that, but I don't really know that much about the business of earning a living by doing that. And, you need someone to show you that the business element of how to use legal services in that business to make the business more profitable overall, whatever your creative endeavor is. And for the lawyer, for creatives, it's going to come down specifically to creating some really great intellectual property assets, a great portfolio of assets that make your business objectively valuable, helping you have great relationships with people on your support team, structuring their incentives in those relationships so that they want to make the business overall better. And it's not just all one-sided or selfish either for them or for the business, but like aligning their incentives with the incentives of the business. That's going to cut down so much stress and make your business better and easier to operate, but also help you build a really great corporate culture. And then, of course, you have the resilience building, making sure that your business is equipped to weather a storm. Even a black swan like COVID is something that a highly profitable business is going to be much better equipped to deal with than one that's like just kind of trying to make it month to month already.
They can be very liquid in those moments of uncertainty, right?
And have structures in place where they're already diversifying, they're already working from home. Like, diversity isn't just about ethnic diversity. It's also about diversity of thought, diversity of opinion. It's also about diversity of sources of revenue, like not having a single client that generates more than 10% of your whole business's revenue. Like if you've got one client that represents 30% of your business's revenue, they can pretty much set the terms. Like if they know that, if they know they represent 30% of your whole business's revenue, they can pretty much demand whatever they want. And you're going to agree to it because if you lose that client, you lose 30% of your revenue, and that might not be something your business can survive. So you need to diversify there, but also vendors and suppliers, having more than one person that you can go to have a problem solved. Like if I need something designed for my business, if I need some graphic design work, I've got a guy in South Africa that I use, and he's really, really great. But what if he's not available? I need to have someone else that I can also send graphic design projects to. So I have to diversify my vendors and suppliers and stuff like that. Diversity is really, really important. And diversification is really, really important in a business.
This is already all beautiful stuff. Thank you for all that so far, Noel.
Sure. Yeah.
So I'd like to push this into sort of like the arena of game design now, or talking about the creative business, right? And this may also share things like graphic design and other sort of similar industries, but two of the big sections of legal that a lot of the listeners had questions about. So I poked my Discord about, hey, as anyone who's listening, if you're part of the Discord, maybe I'll ask you some listener questions to join the Discord, a shameless plug here. But two of the big arenas are copyright and intellectual properties. In fact, one of our listeners today, a week ago, went through a very troubling instance of producing a game that was very good. Everyone was on board for it. They went to Kickstarter, and then they got some unfortunate backlash because it tied so closely to another property. And I don't want to name either of those properties. I don't want to point any attention to this person. But a lot of these, basically the big arenas, intellectual property and copyright, especially as we get into more intellectual property style games, right? Like people who are licensing Marvel to create board games, people who are licensing video game properties to become written content in an RPG fashion. So I guess to start off, what are some of the basic things that we should know about both? Because I know they're different, intellectual properties and copywriting as it comes to maybe like naming a game, or what it has to do when you're sort of transforming that work into another work.
Sure. So intellectual property is the big tent. It's the big umbrella. It's the big net term or concept for a variety of other pieces, parts, terms that fit into intellectual property, right? Within the big tent of intellectual property, you have a booth called copyright. You have another booth called trademarks, and you have another booth called patents, and then a final booth called trade secrets. So among the big under the big tent of intellectual property are copyrights, trademarks, patents, and trade secrets. Now, a trademark is any mark, or it can even be like a jingle, a piece of music, whatever. Think about the fanfare, like 20th Century Fox fanfare, da 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 da, right? Like all that. You got the spotlights going. It says 20th Century Fox. Okay, all of that is a trademark. Even the music, that's all trademark. The MGM Lion, raw, big thing with MGM, Metro Goldwyn Mayer, that's trademark. Any mark that would indicate the source of goods and services is a trademark. And so it's a mark that whenever somebody sees that, they know, okay, this product that I'm consuming came from this particular producer or provider. That's the whole purpose of a trademark. There are also service marks, but these days that's a bit anachronistic. Like it's still a thing. You can still use it. But service marks really are just like if you see the SM instead of the TM, that just means that they're specifically talking about a service and that they're not delivering any products. Products are goods. Services are services. They're consumed, as you use them, and it's one human delivering it to another human, and there may not be any residual thing left. You think about like a massage. That's, pure service. The only thing that you're left with after that service is consumed is just feeling like a big noodle. That's it, right? Like that's the end of that service. You don't get something to take home with you. But if you at the spa, if you go get a massage and you buy the robe as well, okay, now you have some goods. So the spa's name or whatever, like if it's Waterfalls Med Spa or whatever, Waterfalls Relaxation Spa. That Waterfalls, if that was the name of their business, that could be a trademark. And they might use TM, they might use SM. If they're not selling any bathrobes or any products or anything like that, they're only selling massage therapy services, they might use that in connection with an SM mark. But if they're selling goods of some kind, the robe, the essential oils, whatever, then they might use a TM. And these days, a TM can kind of include the SM. So you see much fewer people using the SM mark anymore. It's just easier, and people consider service marks to be almost a type of trademarks. And it's a little bit of intellectual laziness, but hey, that's where our society is. When it comes to copyrights, copyrights are the rights that are held, the ownership rights, the creative rights that are held in connection with a creative work of any kind. So pictures, photography, illustrations, graphic design of any kind, mixed media stuff, books, poems, films, songs, like whole songs, not just like a little, phrase of music, like a jingle, but like a whole song, something like that. All of that would be copyright eligible material. And the copyright springs into existence the moment a creative work is completed. So as soon as you create that work, the person who created it owns the copyright. Now, in order to defend the copyright legally, you ought to register it. And now in the United States, it's a little different from in like a country like Canada. If you hire someone, when it comes to works for hire, if you hire someone to create a work for you in the United States, the default rule is that the person who hired the creative owns the copyright because it's a work for hire. They essentially are paying for the ownership right when they hire that person. In Canada, it's flipped around. It's the other way. In Canada, if I hire a graphic designer to create a logo for my company, I get a license. I'm essentially buying a license to use that logo, but the graphic designer still owns the copyright. They actually own it, can use it, repurpose it, sub-license it out to other people, and so on. The contracts between businesses and creatives can actually change those conditions. You can contract around the law, or you can change the default rule in the law through contracts by using contracts. So the contracts that govern the relationship between a person who's hiring you to create a work and the person who's being hired to create the work are absolutely essential. It's very, very important to get those right. And a lot of those deals today are done on a handshake. It's just a handshake deal. There's no written contract. And that's terrible because you don't really know. It's sometimes very unclear what it is that you're paying for, what it is that you're getting, what the limits of that are, who can use what. It can be confusing. But having a well-written contract for services for the creation of intellectual property, whether it's copyright, trademark, whatever, is very, very important and can leave you in a much stronger position. So you definitely should do that. And it's not nearly as expensive as you would think. The other two are difficult to deal with. They're a little more difficult to deal with. Patents deal with schematics and prototypes and like functional things. There's only one thing that I can think of that can be both copyright protected, and patented, and that's software. When the code is written on a page and published in a book, then it's copyright eligible material. If it's hard coded into an electronic device, then it's patentable. That's the difference. Like functional software working, doing a thing, that's patentable. But in pretty much any printed or other like visible, readable context, it's copyright eligible material. So protecting software, you really kind of have to keep your eye on the ball with both copyright and patent, especially if you're like writing manuals that display your code and this is how you do this thing, if this is how you debug this or whatever. And then finally, the trade secrets. We just passed a couple years ago the Defend Trade Secrets Act in the United States, which really added a lot more protection to trade secrets. But really, these are the things that are valuable because they are secret. You think about the formula for Coca-Cola, right? Could that formula be patented? Yes. Would you want to patent that? No, because the moment you register the patent, it's public and people can just make their own Coca-Cola at home. The thing is only valuable because nobody knows the whole formula. I think it's broken up into several parts and only, one person only sees one part of it at a time. And so like they've done a whole lot to protect their trade secrets. Trade secrets are things that are valuable because they're secret, even if they would be eligible for other kinds of intellectual property protection. They're the kinds of things that They might be systems, processes, unique know-how for how a thing is created or delivered, or what your process is for being more efficient. Like you might be the most efficient producer of X, and the way that you create this product might not be completely unfamiliar to the market as a whole. But your particular pattern for doing things, like your particular methodology, we do this step and then we wait X amount of time and then we do this step and we add these ingredients. The precise way that you execute on the production model might be a trade secret. That's one thing that could be a trade secret. It's very important that creatives and business owners of every stripe hire a lawyer in advance and disclose to them, because you have attorney-client privilege. Your lawyer's not allowed to disclose all of this. Your secrets are safe with your lawyer. But to disclose to your lawyer how things are going on, like in your business, how you get the results that you're getting, what you're doing, what you're creating, and let them advise you about how best to protect that. Let them advise you, okay, well, you should register this trademark as a word mark, just the name of your business, but you also should register it as a composite mark by combining it with the word mark, just the name of your business in words, with your logo. And, because you're using it all together in these contexts, with these products, you're stamping it on this product or whatever, or you're using it on your website to sell these services. So you really should register. Yes, you should register the word mark to protect the name of your business as a trademark, but you should also register a composite mark. And you might even want to, if you're using your logo separately and putting it on things, you might register that separate from the composite mark. So for a business that has a word mark, the name of their business, a logo, and then they use a combination of those things, you might actually be registering 3 separate trademarks: the word mark, the logo, and the composite mark. And the United States Patent and Trademark Office is where you register those trademarks. And if you do the online only application, it's called a TEAS Plus or TEAS Plus application. And it's the filing fee is $225 per mark per class of goods and services. When you go to register your trademarks, you're registering them on a per mark, per class basis, which means they're registered in connection with a certain class of goods and services. There was this guy back in the day who tried to register the word stealth for everything. Stealth. It was like he wanted to own the word stealth. And anytime anybody tried to use the word stealth, he would send them a cease and desist letter. He'd say, I own the trademark to the word stealth, and you're using it, in connection with these goods and services. And I'm the registered trademark owner for this. And so you have to pay me a license fee. And he basically extorted money out of people, threatening to sue them for trademark infringement, until the trademark court just threw him out and banned him for life. He was a trademark troll. He was basically doing what people do with domain names, but he was doing it for trademarks. It's not illegal to camp a domain name and extort a ridiculous fee. Even if you're not using it for anything, you can do that with a domain name. You can't do it with trademarks. So you can't just register something and then just camp on it and extort money from people. So that's not a viable business model. Please don't try to do that. There are bad consequences for that. But if you're actually using it, or if you want to file an application based on your intent to use it, if you're saying, well, I have this trademark and I'm not using it right now, but I'm in the business planning and business development phase of my business, and you're going to start using it in commerce, you're 6 months away from selling goods and services using this mark, then you can file a trademark application based on your intent to use that mark. But you'll have to then file within 6 months, you'll have to file a separate statement of use. And if you don't file it within 6 months, you can file for an extension. And I think you can file up to 5 extensions, I want to say. So, you can extend it out for a long period of time if it takes you longer to get to market than you thought you would. But, every time you file one of those extensions, you have to pay for it. So the longer it takes you to get to market, the more expensive it's going to be. What I advise my clients typically to do, just in general, is wait till you're 6 months from the date of your first sale and then register based on intent to use. That's going to be the right mix of beating anybody else who might want to use that mark or a similar mark to market, beating them to market, first in time, first in right, and all of that. But also it's going to make sure that you don't have to spend a whole lot of money for filing a lot of extensions.
Amazing. And I love also the note of like that you can't reverse trademark a commonly used term to like to do, like, I don't know, it just to weaponize it. I guess that's what I'm trying to say. You can't weaponize trademark, which is good to know.
Shenanigans. People pull all kinds of shenanigans, even in the law. I mean, people think of the law as this like super proper, formal, whatever. There's shenanigans, there's legal shenanigans, but we try to keep it to a minimum. And typically the shenanigans don't carry on too long until a judge somewhere goes, okay, that's enough.
Yeah. So I guess for the lens of tabletop game design, so something that I specifically want to look at is copyright and how that can have potentially legal ramifications for the designer. So let's use an example to help tie this in. So we talked a little bit off air. Noel and I both come from an MMORPG background, and here's my prevailing example. So I have a game idea, right? I want to make a tabletop role-playing game, as trite as this is, off of like World of Warcraft, right? I see some interesting like mechanics that I want to turn into, words. How to do a heroic strike of a warrior, but writing it in such a way that like I'm trying my best to not, because I'm already scared of copyright, I'm trying my best to take this really cool idea I have, switch up these mechanics, turn them into words, into like dice rolls and stuff like that, instead of randomly generate numbers in a video game. I'm basically taking a video game, turning it into a writing words game. What are some of the things that I should be cautious about when I'm approaching that sort of like transformative work? When I see this thing, it inspires me. I want to create something, and I'm doing my absolute best as a designer to avoid copyright issues. What are some things I should tiptoe around?
So there actually is a tabletop RPG for World of Warcraft. You can go online to warcraftrpg.com and you can read about it. I think, and I could be wrong about this, but I think it's based on the D20 system, and Wizards of the Coast has an open gaming license for use of the D20 system. So World of Warcraft, the role-playing game, it actually may not be online anymore. I'm on Gamepedia. In the external links at the bottom of the page, there's like an archived here link. You can see where that site is archived, but you're going to have to license the IP if it's based on existing IP. And when we say IP, we mean in this context, copyrights and trademarks, a mixture of both copyrights and trademarks. World of Warcraft is a trademark. Dungeons and Dragons is also a trademark. There are the owners of the trademarks, in this case, are Blizzard, or Activision Blizzard now. Don't get me started. And Wizards of the Coast in the case of D&D, formerly TSR and blah, 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 right? Lots. The IP has changed hands over the years, both with respect to World of Warcraft and Dungeons and Dragons, but you need to find out who the current owner of those intellectual properties are, or of a property is, and of those properties are, and then obtain a license. Now, for something like the D20 system, there are open licenses, and basically to comply with the terms of an open license, what you need to do, it's kind of like a Creative Commons license, right? You need to read and understand the license, which means you're probably going to need to read it yourself and have your lawyer read it and explain to you anything that you are not 100% crystal clear on. Now, this is an important thing that I want to explain. Anytime a person who's not a lawyer reads a document that could affect your legal rights, I have absolute confidence, or at least I'm going to give you the benefit of the doubt, okay, that you are literate and intelligent and you can understand it. But that's a specific kind of understanding. The understanding that a non-lawyer gets when they read a legal document is a grammatical understanding. It's an English language understanding. You understand what those words mean in the normal context in which they're used in everyday colloquial speech. It is not a legal understanding. The legal understanding of something comes from knowing how legal documents are affected by statutes that are passed by the legislature, either in a state or the federal government, the federal legislature, and understanding how those documents are affected by case law. Because in the United States, we have, judges that render opinions, and those opinions create a binding legal precedent. So a judge's interpretation of a context in a specific set of, of a contract in a specific set of circumstances, or a legal principle in a specific set of circumstances, has binding authority on lower courts or lateral courts in subsequent legal opinions. So for a person to read a contract and say, oh, I understand what that means because I understand the words and the grammar, like I understand the dictionary definitions of those words, that's not the kind of understanding you need to have in order to be fully informed on your legal rights. And that's why even if you're a really smart person, even if you're very highly literate, you completely understand every word of the contract, you still need to have a lawyer review it because you don't have the legal context to give you a legal understanding of that document. So when it comes especially to something complex like a licensing agreement, even for an open license, have that reviewed by a lawyer and have a conversation with the lawyer in which they tell you, here are the limits of what you can do. What is your intention? What are you trying to do? Talk to your lawyer and have the conversation. We love Warcraft. We want to create a tabletop RPG using the open license D20 system from Wizards of the Coast to create basically a D&D that's adapted for the Warcraft universe, where we're using all the Warcraft characters, places, technologies, blah, 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 blah. Like the whole thing, right? Like the whole world. It's basically Dungeons and Dragons in the Warcraft universe instead of the Forgotten Realms campaign setting or Greyhawk or, Dragonlance or whatever. If I didn't name your favorite one, I'm sorry. Just insert your favorite one there. But I like Forgotten Realms, and I'm not going to apologize for it. So that's the one that got named first. Ha ha ha. No, that's petty. But anyway, suffice to say, have your lawyer tell you what it is that you can do with the IP that you want to use, but have the conversation with them, and your lawyer can help you. Like for this, in this case, you may not need to go out and actually obtain a different license from Wizards of the Coast for the D20 system, but you would need to obtain an actual license, like a written license, not an open license, but an actual license agreement from Activision Blizzard to license the Warcraft IP. They don't give open licenses for that. So you're going to need your lawyer to contact their legal department, their legal division, and negotiate the terms of a trademark licensing or copyright licensing agreement. And so that'll be a contract. You should expect to pay a license fee. And typically those are, there might be an initial fee for having the agreement, for the privilege of having that agreement. There might be an initial fee, but typically the main compensation for a trademark license comes from royalties. So they might say, for every dollar that you make, you have to pay us 3 cents or 5 cents out of every dollar, like right off the top. Before any other expenses, you have to pay us off the top a royalty fee. So does that answer your question about copyrights generally, about how to obtain a copyright, like what you should do if you're considering doing this, and like what your general approach should be as a creative game designer who wants to license other people's copyrights and trademarks?
Yeah, I think that's certainly like my way to sort of talk about that proper way of, or maybe not proper isn't the exact term I would use here, more of like the one-to-one. Like I want to make World of Warcraft RPG. Now, the thing that I really want to get to that I see more commonly is sort of like the filing off of the serial numbers, right? So I like the World of Warcraft situation, but I'm not here to use like Durotar. I'm not here to use Orgrimmar, right? I don't want to use any of those terms. I don't even want to use like their setting, right? But I want to use things like the warrior class, the heroic strike, the orcs, trolls, elves, right? Like all those things that seem, all the things that seem very like public domain, kind of, right? I know we'll probably get into a deeper conversation of what that looks like in the copyright world, but it's like, how do you own the concept of an orc, right? When it's existed in novels that have come long before World of Warcraft, right? And then also things like, I have this half version of like a combination of things. So like maybe it's, I don't know, Orgrimmar plus Ironforge equals my city, right? And I just add all these different elements that really transform it. And I'm not trying to say a piece of work that, just scrapes the surface level off and then rewrites the same game.
Yeah.
I'm really like under the consideration of someone's like, okay, I'm really inspired by these mechanical bits and by this narrative that the world spins. I want to transform that into an RPG so I can extrapolate those things into different settings, into different sort of their own intellectual properties. But the real meat of the question is, how does copyright attach itself or can cause problems in instances where like I want to use how a warrior works, right? Like I have to build rage and stuff. Like I insert the sort of rage mechanic and things, but it's not, it has no intellectual property writings of the game, the inspiration. How does that sort of tie into all of this? If that's an answerable question, or if you need a better parsing, I can.
I totally understand that. Okay, so you're talking a little bit about derivative works and the limits of fair use and that sort of thing. When it comes to saying like a phrase like heroic strike, that might be something that could be copyrightable in a very particular context, like a pretty narrow context. But generally, that's so vague that I think normally it would fall under fair use. For fair use, you got to look at the nature and character of the use. Fair use strongly favors, commentary, news-related uses, education, criticism of things, and it disfavors the fair use argument. Disfavors purely commercial uses. So if you're primary, like if you're on YouTube, you're a YouTuber and you're talking about this on your YouTube channel, it's probably fair use. But if you're trying to make your own competing product, making a fair use argument as like the thing that you hang your hat on may not be the best idea. Also, the nature of the copyrighted work matters. Generally, things that are fictional and unpublished have more protection than things that are factual and widely available. So there's that. But again, it comes down to the particular formulation of the material. The amount and the substance, this is where we start to get into some really subjective criteria or somewhat subjective criteria.
Yeah, that's exactly.
The amount and the substance of the portion that you use makes a big difference. With fair use, just think about the old aphorism, less is more. Generally, the law favors fair use that involves a portion of the work that's very, very small in relation to the whole. Of course, if the whole work is really small, like if it's a haiku, for example, right, then, you're not going to have a lot to work with that's going to be proportionately small relative to the whole, because the whole thing is small. And then the effect, and I'd say this is the primary one and the biggest one, at least for me. Like if I were the judge and I were in a copyright infringement case and I were making the judgment, what it would come down to primarily for me, the thing I would give the most weight is the effect of your use of that material on the potential market or the value of the copyright protected work. So if you make something that's so similar to Warcraft that you basically, even though you've relabeled everything and you've called everything the same, basically it's an obvious knockoff. If you do that, then I would say expect a cease and desist letter from Blizzard for copyright infringement and expect to get sued. And even if you win the law, this is another thing to think about. Even if you win the lawsuit for copyright infringement, that can be expensive. Winning a lawsuit, even if you ultimately win, can be expensive. Do you have enough money to win? If you don't have enough resources to win the lawsuit, it doesn't matter that you could win the lawsuit. It doesn't matter that you could. You'll lose because you won't have the money to fight and you'll just get bled out. So you really need to be careful about copyright infringement. It's a super serious thing. A couple of things are, there's a huge list of things that cannot be copyrighted. titles, facts, ideas in general, phrases, like turns of phrase, and any item that's just too small or too short to have any like intrinsic unique value. Those are all categories of things that can't be copyrighted. Parody is okay. So I'm not going to venture into the Rule 34 territory, but let's just say that that parody is fine, and any parodies can protect use of copyright works in order to poke fun at things. That's typically okay, but still sometimes people get hit with cease and desist letters for parodies that hit a little too close to home, or just they're not considered very funny or whatever, or they're offensive. Sometimes there are other problems with those parodies that can result in legal trouble. Pretty much anything, any copyright on a work created after 1978 is good for the life of the author plus 70 years. For works of corporate authorship, you might say, well, this is a copyright's owned by a corporation, so it's not a person. It has a perpetual existence. Then the term is 95 years from the date of publication, or 120 years from the date of creation, whichever is shorter. And once the copyright expires, it falls into public domain. Anybody can use it. It's considered to be part of our cultural heritage, and it's not subject to copyright limitations. So things like orcs, I mean, it's J.R.R. Tolkien, right? Like, I'm not saying he invented orcs, but that he was the first one to really make it popular. So I'd say orcs are public domain now. You can use the concept of an orc. It's totally fine. Orphan works are something else to think about, but I would have you talk to your lawyer about orphan works if you're concerned about those in particular. Like if that's come up in your, as relevant to you as a listener. I don't want to get too tedious in the conversation on a podcast, but suffice to say, you just want to be really careful with derivative works that you're not stealing market share from somebody else. Sure. Like if the big takeaway point from this whole question is if what you're doing is so similar that someone would put the original source material and what you've created side by side, and an objective third-party neutral observer who's not intimately familiar with each of them couldn't really tell them apart, or says, oh yeah, this obviously, like, I see what you did. You took this from over here and you called it a different thing. If you do that, copyright infringement. But if it's unique enough or different enough that there are some really substantial conceptual differences between the two, and you would prefer them for different reasons, like different game mechanics or different different conceptual reasons, then I would say that derivative work might be okay. Because after all, every creative work is to a degree derivative in the sense that it is inspired by something that we've seen. Very few ideas just come to us from nowhere, out of the ether. That's just not really a thing.
Yeah. We've seen something, we forgot about it, but our subconscious kicks it back in like it's a new idea sort of thing. Totally have been in that moment.
Yeah.
So I guess sort of the last follow-up to this particular section of commentary is in that example where you're sort of setting these two derivative works side by side, or the quote unquote original work and then the derivative work side by side. You're sort of saying, oh, these look similar. And you talk about the market. If one is a video game and one is a, pen and paper situation, is that still within the same frame? When we talk about market, are we talking about the brand identity of the original work, or are we talking about the industry in which it sits? Well, or is that, kind of a subjective question?
I think that the games industry is the industry that you're talking about. You'd be talking about like the films industry and obviously toys. Star Wars really made their money on toys, right? Initially. Those were all licensed. The toys were licensed IP, or they were, based on the film renderings of those characters. So I think that copyright material transcends different use cases, if you want to think about it that way. So I don't think you could say, if someone wanted to make the argument, well, I'm not making a video game, I'm making a tabletop game. I don't think that would be a good argument. I don't think you're going to win that one in court. So what I would say to you is, if you are porting content from one context to a different context, you still need to worry about copyright, and you still need to consult with a lawyer about your legal rights and have them advise you about what to do to make sure that you obtain the appropriate licenses. And look, instead of thinking about the creators of original works as competitors, and we have this sort of like gamers, and I'm not here to criticize gamers because I am one and I love them and I love the culture and everything, right? So, but there are some failings that we have as a gamer culture, right? And one of them is tribalism. And you see this played out in console wars, for example. That's just one example. I like Sony or I like Nintendo, so I hate Xbox or whatever. Like, that's kind of a weird nonsense way to behave. And this tribalism tends to play out in other ways. Like when you get attached to something that you really love and you think is the best, there's this sort of subconscious or sometimes conscious psychological need to push down everything even remotely related to it to elevate your own preferred IP. And I had a friend growing up who I asked him, I said, have you ever watched Seinfeld? And he said, no, in the 90s, I watched Friends. And I was like, but you could watch them both, right? You could watch both shows. And he goes, no, I always felt like you had to choose. And I said, what? He was like, yeah, no, I always felt like people were either Seinfeld people or they were Friends people. You didn't really watch both. And I was like, I don't know how to deal with that right now. That's just kind of a crazy thing. And he was like, well, that's just the way it was. And I said, okay, well, I respect it, but I don't understand it, but I respect it. Or people who really prefer Star Wars over Star Trek. You can love them both. It's okay. And when it comes to creating derivative works, I think you should see the creators of original content, even if you're creating something that you believe is superior for whatever reason, you should see the original creator as number one, a source of inspiration, and respect them for that. Even if there are some serious failings in their work, they've still inspired you and contributed to the development of your own ideas, but also they might be potential partners. They might be people who, even if you wouldn't want to be in bed with them, if you wouldn't want to be in business with them necessarily, you can have an arm's length business relationship with them that's mutually beneficial. Consider whoever was like, hey, World of Warcraft would be great as a tabletop RPG. I don't know if that came from someone within Blizzard or if it came from outside of that, someone who developed it. And I don't know how it all came to be. I don't know the story of the tabletop RPG for Warcraft, but let's just say that it was a fan. Let's just imagine a hypothetical universe, a parallel alternate dimension where it was a fan that did that wanted to create a tabletop RPG, right? Maybe that fan wrote it all up in the D20 system. They wrote up a proposal and they said, we're going to basically create, using the D20 open license from Wizards of the Coast, a D20 Warcraft RPG. We're going to develop all the materials. We're going to first do the original, classic WoW campaign setting and everything. Then we're going to do Burning Crusade, Wrath of the Lich King, and so on, right? We're going to do these as like expansion books and kind of follow the natural progression of the Warcraft universe with the creation of all these materials. And then they went, in this hypothetical universe, they went to Blizzard and said, hey guys, we see a market for this. Like a lot of the people who play Warcraft are old school tabletop RPG players from way back or they're people who've wanted to get into D&D, but they have such an attachment to the lore of Warcraft and the world of Warcraft. What they really want to do is play a game that's like D&D, but it's really Warcraft because they love Warcraft. And after all, if someone isn't playing a Warcraft branded game, aren't they kind of getting a little bit away from their monthly subscription? Like, wouldn't you prefer them to play, if they're going to play a tabletop RPG, wouldn't you prefer them to play something that is closely tied to your big moneymaker? And then the Blizzard people go, oh yeah, that's great. We see a market for that. That's wonderful. We'll give you a license, but for every dollar you make, you have to pay us 5 cents.
Sure.
And you might say, great, well, now I'm in bed with Blizzard, and whether that makes you happy or not, you don't really have to think about it too much because you're running the separate business of building the tabletop RPG. It's lateral, it's related, it's closely related. It has a whole lot to do with it. It's derivative, but really it is a separate business. It's there's a separate, a related but separate market. Those market segments between tabletop RPG players and online RPG players, those segments, market segments, almost certainly overlap. But
you're not directly working for Blizzard or Activision. You're kind of in your own bubble, right?
Now, in this case, in this world, I suspect that Blizzard just was like, "Hey, let's do this. Let's make a. It's kind of like Hearthstone.
Let's make money.
Yeah, let's make money. Let's make this separate product. After all, we can completely dominate the MMORPG space, but let's take a crack at the tabletop space. Let's just see what we can do and spin-offs. And I mean, it's like." You can buy a Star Wars version of pretty much any product that you want because it's a popular IP. And if you want Chewbacca fuzzy dice hanging off the mirror of your car, it's out there. I mean, you can do that. So there's really no limit to what a company can do with their IP as long as there's someone out there who's willing to trade their dollars for it. And you should be aware of that if you're creating these things and trying to license, It's like, think about what is there a market for people who are into this IP, into this hobby, this copyrighted material, this world that's been created. For all those people, like what else are they into, and would they like to have a branded version of one of these other things that they're into? And then if you think about targeting that and it's not already being done, then go back to the owner of the IP, license it out, make your pitch. You should have a business proposal that you put in front of them that shows them, here's how much money you would stand to make. Here's what it would cost you to comply with us in the creation of this. Profit,
Sure.
Yeah.
Especially when we're talking about that direct licensing of us, you want to reformulate all the names and things into this product. You don't want to stray away from not using Ogrimmar. You want to use Ogrimmar. You want to use Ironforge and stuff like that. Wow, that's really mind-blowing for me. I'm sure it's mind-blowing for a ton of other people who are listening.
Derivative works are, by the way, might be more creatively satisfying, but do you want to be a starving artist, or do you want to be people are like, well, I don't want to be a sellout either. It's like, but you do want to earn a living. And I would say that you look at people like, I don't want to call out names, but just look at successful artists out there, right? Sometimes they do things that are their clear money makers, and then they have other projects that are their more pure artistic expressions. And I would say, look at those kinds of creatives. They're the ones who are the smartest in business and the best in business. And it doesn't take anything away from their purely creative projects or works, that they also have some things that they did to make money, that it's not as purely creative. It's not as bold or avant-garde or risky or whatever in a creative way. Like, there's clearly a mass appeal commercial component to it. But how can you be a long-term successful creative professional if you don't make a living doing it? I strongly believe Alan Watts, what he said when he gave that great talk about what do you desire? Ask yourself, what do you desire? In fact, it's so great that I put it on our blog at executivelp.com. You can search for what do you desire? And there's this video clip that we just embedded right there. And it's a really inspirational thing. I probably watch it at least once a month, and it keeps me focused on going after my passion and what I desire. But he talks about not making the money the main thing. And I 100% agree with that. You should follow your passion. You should do what you love and not make the money the main thing. But that doesn't mean that you should ignore it. It's not all or nothing. At the margins, all decisions are made at the margins. And at the margins, you do need to pay attention. You need to pay marginally more attention, at least in the early phase of your career as a creative, to the types of projects that are likely to earn money for you. The longer you are a successful creative professional, and the bigger your portfolio is, the more financial success you've had, proportionally, the more freedom you'll have to take bigger risks. That's what paying your dues means. It means now people have come to value my creative work, and I've done things that other people value. I've created for other people for so long that now they respect me and my creative vision. I've earned that. You don't just start off with that. You're not entitled to that day one. You're not. You have to go out and prove that you can create things that other people value highly. Well, once you do that, then you will have paid your dues. When you're able to make a living as an artist, then you get to do purely creative things. But to go out and say, my work's as good as so-and-so, I'm going to say, who's willing to pay you for that? If so-and-so's selling, if Andy Warhol's selling, paintings for millions, and you're like, oh, it's just the same thing 4 times in different color palettes. So effing what? Or it's a Campbell soup can. So effing what? I could do that. Yeah, but nobody's going to pay you millions of dollars for yours. They will a Warhol because it's Warhol.
It's the brand of Warhol that provides the value to that piece of artistic creativity, which is, when we talk about the difference between a creative work and like a functional work, right? Because for your business, we talked about how you can look at the trending of like, what is this specific service or product worth, right? We pay $3 or $2 for an apple or for a bushel of apples or whatever, because that's the common thread at which people are willing to pay for that function, right? And that's kind of like the baseline. But when it comes to art, at some expense, it's sort of a luxury product, right? And we don't really have like a function for it. So it's hard to put a price, a specific median line price for it. So now that artistic endeavor gets attached to the person, the brand, how you feel about who is creating that piece of art at the end of the day.
Or it might be a functional thing in from a psychological or spiritual perspective. It might be like, well, when I look at this rabbit in the snow painting, that's just like different textures and shades of white. Basically, it's just a big white canvas, white on white, right? Rabbit in the snow. Or I'm thinking about that painting that Kingpin loved from Daredevil, the Daredevil series on Netflix, and he would look at it. So, like, what is the effect of something like that worth? What's the profound effect of a painting? With every time you see it, it grabs you and it pulls you to a particular memory or a particular emotion. It centers you. What is that experience worth to you? If you can create art like that, don't tell me that's not functional. I mean, it definitely is.
That's a good point. That's a very good point.
But you have to know that, and you've got to sell. No, well, I mean, it's just the thing. You've got to sell that. You've got to know that that's the function that art has. It's about evoking a specific emotion, like a specific piece that grabs a specific person, and it grabs them so hard and it directs them to such a particular experience that they're willing to trade you dollars for that. That's how you know that you are a great artist, that you can create things that are not just compelling for that one person, but have that effect on many people. And when your work has that compelling effect on many people, then you're a successful commercial artist. Now to create things that are for you, and you say, well, my art is for me and I create for me. And, it has this profound effect on me. I'm like, great. You're now a market of one and a supplier of one. You're selling to yourself. So that's not universally valuable, because if you have resources, you're just like, well, I'm going to pay myself for this. So you're just shuffling resources around. You're not like actually getting them from another person. So I think people who are successful in business create things that other people value highly. That's one of the fundamental laws of economics is, people get rich by helping others. People get rich by creating goods and services that other people value highly. And if you want to be successful as an artist and like in your career, be a professionally successful artist, you have to create art that other people value highly. And the more you do that, the more your personal brand will grow, the more cachet you'll have, the more authority you'll have, and the more you'll have the freedom to create things that really inspire you, because people will, the sort of the credit that you've created for them for years, the social credit that you've had that you've built from moving them all these years, will translate into just love for you and your particular feeling or nuance or your artistic voice, or however you want to describe it. People will start to value that intrinsically, and then whatever appeals to you, they'll buy it. And even if it's silly, I mean, like, there have been lots of silly art projects that have resulted in a lot of spending, like high valued art projects that when you look at it objectively, it just is like, why? It's a dude that slathered himself in paint and rolled around. I mean, like those sort of abstract works. They're valuable because of who created them and who they sold them to and other things, but they don't necessarily have mass appeal. But that doesn't make them less valuable to the people who are willing to buy them. It's just a niche. So you should also, carve out your niche, speak to your market. And you have to know, like, all of these things that you do as a creative that make you a good creative, a good artist or whatever, can also make you a good business person. I think that today's world requires leaders who see through the eyes of an artist, not data analysts, not, numbers crunchers people. I think it's really the artists who will lead because we live in such an emotional world. But you definitely need the support of the number crunchers, the data analysts, the professionals, the lawyers, the accountants, all of that. And you should listen to them. You should listen to them and involve them early and often in your decision-making process, and then take their advice.
Mm-hmm. Yeah, it's definitely form that council around your own particular support system and hire those individuals that will do that side of the work for you so that you can focus on producing that emotional support for the greater human populace.
Totally.
Right?
Yeah, totally. Perfect.
Yeah. Thank you. Wow. Well, I think sort of the last, again, thank you for all of that. Really, really good stuff. The last bit on here, I guess the last two bits on here, you sort of already slightly covered it when you talked about the OGL for D&D, for the D20 system. But I did have a question from a listener about the legal perspective of a system reference document like the Open Gaming License. So there's, I don't know if you're familiar with it, but there's a game called Blades in the Dark by John Harper that has a sort of 4.0 Creative Commons license attribution type of thing. Put our logo in this little paragraph in our book if you're using any sort of pieces from our SRD. The reason I bring it up is because this sort of falls into that same section of derivative work concepts, right? Some people, at least under my assumption of the listener question, is that when it's going to be subjective, it's going to be nuanced, it's going to be complex. There's no two ways about this question, but what is the point in which you would attribute that work? And I think this is similar to the derivative works question, like the original source. When do you put that mark in there? When do you have to attribute? And then, like, when is your work so far separate that, like, you don't really have to, but you may still be like, for example, if in his game there is a concept of clocks. It's basically a circle that's segmented and it represents progress tracking in some fashion within the game. I've put clocks into my game, but it's the only thing that I've put into the game. And it's not an original concept by his work, but it is a part of his SRD. So do I put the attribution license in there, or do I just have a little sentence blurb that says, hey, this has some basis off of the Blades in the Dark game?
I think it's always good to pay tribute to your sources of inspiration. It's kind of like if you were writing a paper in school, and you used a little quote from a book that, you'd read or a report that you found. It's good to have a citation there. I don't think, unless you're taking his concept of clocks and you're utilizing that particular concept, I don't know that you necessarily need to worry too much about the license. Now, is his Creative Commons license the no derivatives license? Because there are some that are no derivatives, non-commercial use. There are quite a few Creative Commons licenses. And so you'd have to look at the particular Creative Commons license that he's using. Do you happen to know which one it is?
Let me see if I can see it in this book that I have.
Because there's like CC0, there's the public domain mark, there's the attribution mark.
The CC one sounds similar, like that. Let me see if I can pull up the SRD. Jeremy, edit this section out. This dead air.
So there are the some rights reserved. and the you need to make sure that you're combining if you're creating a Creative Commons license, or if you're using one, you need to know the key license terms. The key license terms for a Creative Commons license are attribution, no derivative works. Attribution is the mark that says by, by. No derivative works is the equals sign and ND, November Delta. And then share alike, which is SA, and it has the sort of recycling like circle with the arrow. It's a circle arrow. And then there's the non-commercial, which is the $ crossed out. And there are, I want to say, 8 different combinations of these for the license in public domain. So like you can combine these all kinds of different ways. There may be more than 8, but those are the ones that I am most familiar with. And you need to make sure that you're looking at the correct Creative Commons license and you know what all those terms mean. Attribution means that others can, if it's just attribution alone, then others can copy, distribute, display, perform, and remix your work if they credit your name as requested by you. It looks like his is, let's see, Blades in the Dark, product of 1.7 Design, Creative Commons Attribution 3.0 unported license for Blades in the Dark. So this one is the CC BY. So you're free to share and redistribute the material in any medium or any format, and you're free to adapt. So that adapt means derivative works, remix, transform, build upon the material for any purpose, even commercially. So I would say for this particular thing, the best thing for you to do would be to give him an attribution. And just say, look, this concept of the clocks as used in this story was inspired by, the Blades in the Dark material owned by 1.7 Design and developed and authored by John Harper. You don't necessarily have to throw his Creative Commons license in there, but if you check all those boxes, I think you would be okay. And you know what? It's never a bad idea to email someone like Mr. Harper and say, hey, this is what I'm doing. This is what I'm doing with your work. Your work is licensed under this Creative Commons license. My understanding is that I could do this with it. Is that cool with you? By the way, like you've inspired me to create this thing. Is it cool with you if I do this? And if he replies and emails you and says, yeah, love what you're doing. That's really cool. Then you've basically got his blessing and you don't have to worry about it. The old saying that it's easier to ask forgiveness than permission, not true of copyright.
Sure. Totally jive with that as well.
Yeah.
So I think basically to sort of sum it up, look at the particular licensing, kind of analyze exactly what it's asking you to do and where, if any, I think what's important to say is don't look for wiggle room here.
Yes.
But if you're that person that doesn't want to dive into every symbol and figure out what that means, and you're just potentially not doing your due credit to do that stuff, probably ask is a good first step, but also, cover your bases, at least form some sort of ludography of, this work is pieced together by this combat system is inspired by World of Warcraft, right? Or, if it was that same sort of structure, right?
And the more,
just say, hey, I recognize this is what I'm doing.
Yeah, totally. And sorry to cut you off, but the bigger and more litigious the owner of the copyright material is, the more cautious you should be, and the more you should expect them to say no, right? But if it's one dude who created this, who's created a bunch of material, and he's an artist too, and you feel sort of simpatico, you feel this sense of artistic kinship with him or whatever. I mean, I'm not saying use that in a manipulative way. But wouldn't you like that as well? At the end of the day, whether it's me developing my law firm or you collaborating with other artists to create new things that inspire people, I mean, we can all abide by the golden rule. For me, that was asking what would an entrepreneur or a small business want their relationship with their lawyer to look like, and then developing a business model based around that. For you, it might be do unto others as you'd have them do unto you in a creative context. If you would want someone to ask for your permission to use your work in that way, then you should ask other people for their permission to use the work in that same way. It's do unto others as you would have them do unto you. I mean, that's just a really great principle of reciprocal kindness, consideration, compassion.
Mm-hmm. Great. That's a beautiful answer, and kind of what, based on our last hour of conversation, I thought the answer was going to be anyways, but I wanted to make sure it was out there for people who it may not be clear for.
Totally. Yeah.
The last little bit here as we start to wrap up, my last question from a listener is that when does it sort of make sense to become an LLC from at what point do you start thinking about I'm really starting to rake in, an amount of income here from my creative properties, and I kind of want to separate that from my personal bank account? When does that sort of make the most sense? For me, I always think that right off the bat, if you really think you're going to dive in to doing this thing, just do the limited liability clause. It protects your own bank accounts and stuff like that. But I'd love a more professional take on that.
Right. So a limited liability company or a corporation, both of those are separate legal entities. Imagine you're creating an android that is going to own all of the things that you associate with that business. Now, the android is completely subservient to you. It does not have a will of its own, but it does have the legal right to own property. And everything that it does, you're not personally responsible for, but you're the one really telling it, okay, Android, go do X, Y, and Z. And you can do things on behalf of the Android, and you can say, hey, I'm doing this in my capacity as a representative of this Android who needs me in order to function. But it's really his stuff, his intellectual property, his rights, right? So you kind of have to conceptualize these companies, these LLCs and corporations, as separate legal entities, a separate person. And in the tax code, it refers to them as a separate person. And if you remember years ago, the Occupy Wall Street moment or movement where they were saying, yeah, companies are not people. That's factually wrong. Companies are people. The Internal Revenue Code refers to them as people. Now, they are not a natural person. They're not a human born of flesh and blood, but they are a legal person and they're a separate person. When you create one of these people, you have to be equipped. You have to be prepared to operate them. It's like, if you don't want to think about it as an Android, think about it as a mech. And when you get into that mech, right, and you're kind of stomping around and shooting lasers, right? Everything you do while you're in the mech is mech responsibility, and it's going to protect you. If someone's shooting at you, it's not going to hit you directly. It's going to hit the mech. Now, if you're grossly irresponsible or you're just a really bad mech pilot, then some of those might break through and actually injure you personally, right? It's not just going to damage the suit. So you do have to be really responsible with that, careful how you use it. And to get away from the metaphor a little bit and be a little more specific and answer your question, I mean, you first need to start with the right mindset, the right frame of mind, and think about it conceptually in the right way. But functionally, in a practical way, you also need to be prepared to do some specific things and to know when to do them. I would say anytime you want a business to be bigger than you as an individual, or bigger than you and your buddy or buddies, like whoever you've got to build the business together, when you want it to be bigger than those people, you need to create an entity. When you want to create something that has objective value independent of what you bring to the table, then consider forming an entity. And you really should talk to a lawyer and present a business plan. So what you want to do is write the business plan first, when you have the idea, when you have the seed of an idea, the germ of an idea, and really think about who you're going to get involved. Who is going to be the key person that everybody associates with that brand? Who's going to be the person that's a sort of influencer, the personal brand that business is going to be tied to? You might think about Steve Jobs and Apple, right? Steve Jobs was the personal brand most associated with Apple. Bill Gates and Microsoft. I mean, there are these key people of influence in an industry who are associated with businesses, and business brands, especially on social media, tend to tie themselves and align tie themselves to and align themselves with key people of influence. So who's going to be that person? Who's that founder? Who's the figurehead of the business? Who's the CEO? Who's going to basically talk to the head of marketing and sales, the head of finance and accounts, and the head of operations who gets stuff done in the business every day? Who's going to bring those people together and be the glue that holds your whole leadership team together? And then who are you going to have in those functional specific roles? Who's going to be in charge of marketing and sales? Who's going to be in charge of finance and accounts? Who's going to be in charge of operations? And I would say that a successful lifestyle boutique business that's making between $5 and $10 million in revenue, like if your target is to build to that so that everybody can live a nice life and have enough income and not really have to worry too much about, where the money's coming from, you're going to have enough money coming in to pay the expenses of the business, and you're going to kind of stay and hover at that $5 to $10 million of revenue level, then you're going to need a 4-person leadership team. You're going to need that CEO. You're going to need the head of marketing and sales. You're going to need the head of finance and accounts. You're going to need the head of operations. Each of those people should have a contract with the company that governs their employment. You're probably going to also need to have other lower level managers and employees in your organization or independent contractors, but a team of 4 can run a business of that size. You need to understand the life cycle of a business and where you are. Like early stages, it might be best for your business to be run as a partnership, not a limited liability company, not a corporation. Run it as a general partnership. Have adequate insurance to cover any liabilities. Use contracts. Have legal counsel. You don't have to have the liability shield of an LLC or a corporation in order to be adequately protected when you're very small and your business is low risk. As you start to build things that might be higher risk for you or need to be objectively owned and independently held in a legal entity to, where you can build value that's attached to the company and the brand of the company, as you're building that and you reach that lifestyle, you start to approach the lifestyle business, that might be the first point where you start to have more conversations with your lawyer about, should we transition from a partnership into a limited liability company or even a small corporation? If you're doing things on Kickstarter or, where you're raising a lot of money, you don't have to worry so much about, having a corporation or having an LLC. But like in terms of like legal protection and who gets the funds, like you can get funds from Kickstarter as a person, right? But at the same time, it might create more investor confidence that even though they're not investing in your company per se, they're investing in products and getting specific rewards. It might create and inspire more confidence in what you're doing, and it might show a degree of business sophistication for you to form one of these entities. That alone is not a good enough reason to do it, but it is one of those contributing factors that you can think about. If you're trying to do equity crowdfunding, however, which was Title III of the Jobs Act, which was passed under the Obama administration and the subsequent regulation that's followed it. If you're trying to raise investment in the business itself through crowdfunding, equity crowdfunding, then you're going to need a corporation. Yeah. So at that point, like when you need the entity, when you need the legal entity, when you need the LLC or the corporation or whatever, comes down to the life cycle of your business, what your goals are, what you're building, whether it has value independent of who you are, how big your team is. There are a lot of factors. There's no one trigger point, and it's going to be different for pretty much every business. I would caution you against trying to use a one-size-fits-all solution or trying to think about this as something that's fire and forget. It's not something that you do one and done. It's something that you create it, then you maintain it, and it grows and it's dynamic, and you can shift from one type of entity to another based on where you are strategically in your business, the life cycle of your business, and what your goals are, what your assets are, what your team is, who your investors are and how much they're trying to invest and so on and so forth. Typically a large performance-driven enterprise like a global small business that's making 25 million or more in revenue, something like that, it's more common for them to be a corporation, whereas the startup that's struggling through the wilderness of getting from startup to lifestyle business and struggling boutique, and they have less than $1 million in revenue, totally reasonable for them to be a sole proprietorship if it's just one owner. And, if you're going to do that, if you're going to have just one owner and the other people work for that person, not with him, but for him, then you need to make sure you have good employment contracts that disclaim any partnership relationship and say, no state law partnership. We're not two or more people doing business together for profit. It's this guy who owns the whole business, or gal, or whomever, right? Whatever your preferred pronoun is. It's this person who owns the business, and then these people work for them as employees or independent contractors. And then if you have two or more people doing business together for profit, you have a partnership, and you want to specifically have a partnership agreement that sets out the rights and obligations of the partners, who they are, who is in the partnership, who's not, what their relationship is to other people who are doing work in connection with the business, and so on. And really, I think for a lot of people, they use LLCs to kind of simplify some of that stuff, but it might be overkill, and it can be kind of expensive overkill because, at least in Tennessee, it costs $400 a year to create and maintain the existence of a limited liability company. It's $300 a year to the Secretary of State for your initial registration, the filing of articles of organization, and then the annual report. And you also owe a minimum $100 a year to the Department of Revenue for your franchise and excise tax. And in other states, you may have corporate income tax that you have to comply with. There are all these taxes, regulations, and fees. And you might say, well, I'll form in Delaware or Nevada or whatever. But if you do that, you might form your company in that state, but then you might also have to register to do business in your own state. So like a company like Tennessee that forms a Delaware corporation and then they do business in Tennessee, they probably need to register with the state of Tennessee. And so it's actually going to end up costing them more. They'll have the duplicative regulation, duplicative registration requirement, and so doing everything twice. And really, if you're only doing business in one state, it might be best to just form the entity in that state, whether it's a company, a LLC, or a corporation or whatever. The bottom line is, this is not an easy, it seems like an easy question, and there's a lot of stuff online that will mislead you into paying some money to do something that's not necessarily the right thing. That's kind of a DIY solution. And that's going to be like buying a Halloween costume. It might say one size fits all on the tag, but have you ever bought a Halloween costume? How'd that work out for you? Was it really one size fits all? The best thing to do, you really want your company to be more like a Comic-Con cosplay costume that's designed to win the competition, right? That's what you want. You want something custom made for you, like handcrafted, stitched together with quality and good materials. And the way you get that in a corporate business formation context is you call a lawyer, you have a conversation, you tell them what your goals are, you listen to their advice, and then you follow it. And if you do that, you'll get a much better result, and you won't have to pay to fix it later.
Yeah. It sounds like sort of the sort of wrap up of all of that is that it's a question of what scale are you at, right?
Yes.
If you're a single person working by yourself, you probably don't really need to delve into LLC, even though, you might read it, provide some protections, if someone would like to sue you or whatever have you. I think that might be a little bit less of a concern unless, you're dabbling in copyright area, but then you should have a lawyer, right?
Yeah.
But you start advancing into that LLC territory when you start adding other people of equal sort of responsibility for the creative endeavors you're involved in, right? When you start having someone who's managing all your social media accounts, someone who's handling all of your financial work, someone who's handling all of your project management sources, working with art direction and everything like that. When you start adding people at a common level, you're hiring the same person over and over again. You're like, okay, I really like to form a partnership with you. Let's start to evolve this business. It's starting to scale to a point where I can't protect everyone underneath or myself underneath this enclosure of business, right? So let me change into something else. And then
more owners
continuing
and
to
more
analyze that scalability.
Yeah. Oh, sorry. We had the audio cut out there for a second. But yeah, more owners and more collaborators, people who have skin in the game, right, allow you to scale up your organization. Having skin in the game is what it really comes down to with, do you want to have an LLC? Do you want to have a corporation? Do you want to have a partnership? Who has skin in the game? And you might say, well, as I'm scaling up early on when revenue is low or we don't have any revenue, we have some basic level of investment to kind of get things done. People who've brought some money, invested some money, but we don't really have any revenue yet. You're going to have to pay people for their work, right? And one way to compensate people, at least in part, is through equity in the business. You can give them an ownership stake in the business. How you structure that and whether or not you're in compliance with the wage and hour laws is a very technical legal issue that you need to talk to your lawyer about. So if you're considering saying, well, I need someone to be my director of operations or my director of finances and accounts or my director of marketing and sales, but I can't pay you a salary yet, or I can only pay you minimum wage, right, for your work, but I'll give you this percentage of ownership in the company. That's a good way to grow your initial team and have like founders on board who are like, their interests are aligned with yours. When the company makes money, when it makes a big profit, then they make money. They get to participate in those distributions of profit. And so that can be a good way to scale your early team, but you need to find people who share your vision and believe in what you're doing and are willing to build it alongside you. And that's often a good trigger point for starting a company.
Bless you, I'll edit it out.
Yeah, I hit the mute. Sorry about that. Yeah.
No, you're good. Well then, Noel, I think that is going to bring us to the top of the show at the end here. I don't know how to thank you enough for the information that you provided here today. It's all really good stuff. And I think it definitely distills a lot of that Google searching headache that people would probably have to go through to find potentially 50% of the true information they need out there, right? So I'm really happy to have you on here. Why don't you do a final plug of like where people can find you, hit you up? I mean, obviously all these links will be in the show notes, but give your little plug spiel here.
Yeah. So I just actually want to give you a resource. I don't want to just plug myself, but I most of my marketing, I've spent very little on advertising over the last 8 years of running Executive LP. Instead, what I prefer to do is create things of value to other people. And then if it's valuable to you, hopefully you'll share it. And, it's, each one teach one and all that stuff. So what I want to direct your audience to, since we've been talking so much about business formation and intellectual property in this episode, is I have a book. It's very cheap. It's on Amazon. It's called How to Structure Your Business for Success. Not the best title, not sexy or catchy, but it does what it says on the tin. How to Structure Your Business for Success. It's also available through the self-publishing sales platform aer.io, but you can grab it off Amazon, wherever other books are, wherever good books are sold. It's How to Structure Your Business for Success. Self-published, distributed through Ingram Spark. That was the self-publishing platform I used. So if you're writing a book or you're interested in that, I had a good experience with Ingram Spark. I really like them a lot. But they're the ones who helped me print and distribute my book. So you can buy that, How to Structure Your Business for Success. And if you're interested in what I'm doing with how, profit from legal, basically transforming legal from a cost center in your business into a profit engine for your business, you can go to profitfromlegal.com and read more about that. And pretty much all the services that I offer are described in great detail on executivelp.com. My law firm is Executive Legal Professionals, PLLC. We're a professional limited liability company, but it's executivelp.com. There's a blog there with tons of free resources. We have links to PDF reports and Our digital diagnostic tool is available. It's linked from profitfromlegal.com. You can go and take our digital diagnostic. And that's kind of the last resource that I'll direct your attention to. The digital diagnostic we have is called the Legal Profitability Scorecard. And the reason that you want to take this, even if you don't have a lawyer, whether you have a lawyer, you don't have a lawyer, take the Legal Profitability Scorecard, because as you read through the questions, and there are 40 questions, and they might be unfamiliar to you, but just do the best you can with it. The value is in reading the questions. As you read the questions, you're going to get a sense of what it is that a lawyer can do for your business on a regular basis. If you're like, I don't even know what I would use a lawyer for, I don't need a lawyer, I've never been sued, I can't tell you how many times I hear that. I hear that from people at networking events and so on, like, oh, I'm so glad I haven't needed a lawyer yet. And every time I hear that, I think this is a person saying this who doesn't know what a lawyer is for. They don't really know, they don't know the job that's a tool for, right? They don't know they've never encountered the problem that's the solution for. They haven't yet, but they probably will. And the time to get the solution, the time to buy the tool, is before you have the problem. It's when you can prevent your risk that you always have from becoming a problem that, if it goes unsolved, could be a crisis in your business. So don't have the crisis, don't even have the problem, just keep things, a risk that's well managed. The way you do that is with a lawyer. And if you can't imagine what you could possibly need a lawyer for, take the digital diagnostic. It will tell you. And then you'll get 2 free gifts from us just for taking the digital diagnostic and completing it. The first one is our legal profitability report. It explains what legal profitability is, how to use, basically a bit about legal key performance indicators in your business. This is what a lawyer should do, and here's how to measure whether or not they're doing a good job, basically is what's up. And then the second gift is our 5 Legal Ease Canvas. And this is a really great template that you can use to solve problems or improve relationships in business generally, however, right? The 5 Legal Ease is our signature method. And this canvas that you can download for free contains an exercise that, if you follow the exercise, you follow the instructions that are in there, it'll help you solve problems better, manage relationships better. It's designed to be an introduction to thinking like a lawyer a little bit more. So without, being, I don't know, the stereotypical lawyer person, right? Like, I think people think of lawyers as stuffy, that you think of, like, even in a gaming context, what do we call the guy who's always the red mage, like sticking it to you with the rules, right? They're rules lawyers. It's kind of a derogatory term, but we want you to think in a way that, takes into account other people's incentives and the rules of the game that we're all playing by, whether that's the game of life or the game of business or whatever. You kind of have to be aware of the rules and not violate them so that you don't hurt yourself. It's all about protection, increased productivity, less stress. Like, we all have a more fun gaming experience when we play by the rules. It's the same way in business. Business is a lot more fun when you play by the rules. Otherwise, it's just chaos and everybody gets really paranoid really fast.
Yeah.
So that's it. I'm not even plugging myself. I mean, I'm directing your attention to resources, but I'm not asking you to buy anything from me. I just want you to have these things that we've created for you, because you can access all of the things that I mentioned, except for the book, for free. The book is cheap. The other things are free. Tons of free resources out there for you. And of course, you can tune into the Profit from Legal podcast, and we'll tell you more about free resources and how you can use legal to do better in your business. Profit is what happens when you get everything else right. That's what Yvon Chouinard said, and I agree with that. Profit is what happens when you get everything else right, and I'm just here to help you get it all right.
Awesome. Thank you so much, Noel. For everyone that's listening, I've had an absolute pleasure learning from Noel. I hope you did as well, and we will see you on the next episode of Draw Your Dice. Say bye to the people, Noel.
Bye, everybody. Thanks for having me on, and I really appreciate, Jeremy, you inviting me to be on your podcast. It's just been a wonderful, lovely experience, and just happy I could provide some value for you guys today. Thanks again.
It was a pleasure having you on as well. All right, that's a wrap. Lots of really good starting points to munch on when it comes to the growth of our endeavors to earn a living doing what we love. Thank you for the insight, Noel. All the links to get in touch with Noel will be down below in the show notes for your access. If you like the show and found it helpful, send a tip my way by following the link tree in the show notes to my Ko-fi or Venmo profiles. Or, if you are unable to provide monetary support, you can provide support at no cost by sharing this with someone you thought of while listening to this episode and leaving a review. Both of these methods greatly impact the success of this show and lets me know that what I'm doing is beneficial to designers out there. If you want to be a part of the conversation or hang out with alumni like Noel, you can visit the DYD House Discord server. Thanks for listening, and I will catch you next time.